Stunning story out of Idaho when a mentally challenged black student athlete raped by several white teammates. That's right, folks. It is a stunning story that we bringing to you. And so here's what happened. The victim, African American. And what happened is all the teammates accused, of course, there are white. The rape took place in a high school locker room in the small town of Dietrich, Ohio. This is according to a civil lawsuit. The suspects, John R.K. Howard, Tanner Ward, and an unidentified 16-year-old, tricked the victim into accepting a hug. When the victim extended his arms for the hug, one of the football players grabbed him, held him down, while the other forced a coat hanger into his rectum. The third player then kicked the coat hanger several times. The incident took place in October 2015. It's been under investigation for months. Now, earlier this spring, Howard and Ward were charged as adults with forcible sexual penetration by use of a foreign object. According to the law in Idaho, every person who, for the purpose of sexual arousal, gratification, or abuse, causes the penetration, however slight, of a genital or anal opening of another person by any object, instrument, or device shall be guilty of a felony and shall be punished by imprisonment in the state prison for not more than life. The third suspect was charged as a juvenile, and all records in his case are sealed. In addition to the criminal charges, a $10 million federal civil lawsuit has been filed against the school district earlier this month. That lawsuit claims a young black teenager had also been a victim of countless racial and physical assaults by several members of the football team. The victim, according to the lawsuit, quote, was taunted and called racist names by other members of the team, which included Kool-Aid, chicken eater, watermelon, and the N-word. Another student drew this picture on the chalkboard at the school showing that the victim should sit in the back of the school bus. The civil suit also includes 11 administrators and coaches who did nothing to stop the racial and physical abuse toward the victim. Joining us via Skype to discuss this is the attorney representing the victim's family in the civil lawsuit, Lee Schlender. And of course, on our panel here, Dr. Jason Johnson, columnist and political science professor, Laura Coates, former federal prosecutor, Matt Stevens, political commentator and host of Politics and Prune Juice podcast, and George Jefferson Nuri, founding CEO of In the Public Eye Communications. This suit, Mr. Schleiber, is just stunning. And first and foremost, you allege the district and the coaches did nothing and they were aware of what was going on?
Yes, as far as we can tell. Remember that we have just begun our case. That the criminal case is the one that's really now active, and that's being handled by the Attorney General's office of Idaho. So the facts that we get as far as specific things that happened, who did what, are largely from the hearings in that case, which are now ongoing.
So, first of all, why did it take so long on the criminal side for them to be charged?
Well, it really didn't. The final act, the anal rape, occurred on or about October 22nd, 23rd, depending upon various reports. And from the time it was investigated and then put together, the prosecuting attorney, the local one out there in this little town, had to make a decision whether they were going to proceed or they were going to send it on to the state and use the Attorney General's resources and people to assist them in the case. And that's what they did. I think they did it appropriately. This young man
is described as mentally challenged. Now, was he on the football team or working with the team?
No, this is his first year of going out for football. He had always dreamed of playing football, and as all kids do. And he wanted to make the team very badly, and he went out in the summer to the football camps and made the team.
And so we say describing his mentally challenged, exactly what is his condition?
Rather than describe, specifically what his issues are, I'd rather just say that he was handicapped and disabled to the extent that under federal and state programs, he was entitled to have a tutor with him. And in class, not on the football field, not in the locker room, but in class, he had someone with him who had been assigned by the state. And he was doing very well. They have a wonderful family. and he was very well adjusted and doing fine in school.
What is the next phase?
Next phase is our investigation and what we call discovery in the United States federal court. We will be getting the statements of those people involved. We'll be making decisions as to how to proceed down the line here, and we expect it will be some time before there's much real development as far as our civil case goes against the school district.
All right, Lee Schlender, we certainly appreciate it. Thank you so very much for joining us from Idaho.
Sure.
There's also another major story making news, folks, and that is out of Baltimore. A couple of the officers who have been charged their involvement in the death of Freddie Gray, they are now suing State's Attorney Marilyn Mosby for defamation and invasion of privacy. Those officers are Sergeant Alicia White and William Porter. Both are facing charges of involuntary manslaughter for Gray's death in April. They claim, April 2015, they claim Mosby knew the charges filed against them at the news conference last year were false. The lawsuit alleges Mosby made certain statements just to calm the riots and protests in Baltimore. Joining me on phone is attorney A. Dwight Pettit, and he litigates civil cases in Baltimore, but is not connected to this case. So, Attorney Pettit, what do you make of this suit? It seems as if they're trying to go after her for doing what is described as her job.
Well, I think the suit has a long way to go in terms of legal survival. I think what you're seeing there, Roland, in my opinion, is what they call the best defense sometimes is offense. But these cases are very, in my opinion, strangely timed because of the fact that White has not gone to trial yet, and Porter went to trial, and it was a mistrial. And no motions or anything were granted in terms of insufficiency of evidence, and so, it went to a jury. And so it's going to be very interesting how you can talk about false allegations or reckless disregard for the truth when the first case went to the trial and Officer White's case is yet to be tried.
Okay, but again, filing suit against her, saying she made statements at a news conference, that's what prosecutors do at a news conference.
Well, I think, here we're talking about prosecutors and judges. In most cases, they are state officials, and they have absolute immunity. Now, that immunity moves to a second degree of what you call qualified immunity, but that usually requires to get past the qualified immunity, you have to show a reckless disregard for the truth. In other words, or falsity. You knew that it was false, and you went ahead and made the statements. But that, in my opinion, is going to also require a certain degree of malice. And I think that's why I said it's a very uphill case, in my opinion, to establish legal liability in terms of Ms. Mosby's conduct, either in court or in terms of making the statements she made prior to court and coming from the statement of charges and indictment.
All right, Attorney Pettit, we certainly appreciate it. Thank you so very much. I want to go to our panel here. This sort of reminds me of the guy in Chicago who is suing the family who sued him for civil charges by saying, well, they're causing me distress because I shot and killed their son, and so I'm going to sue them.
What they're doing is capitalizing on the fact that you got a hung jury and you got an acquittal with the former officer. And so they're trying to say, look, none of these charges are ever going to stick. She must have known they were false. But the problem with that, of course, is they had a hung jury. They had to actually deliberate these facts. As she knew them on that day on the War Memorial, these are things she actually believed, and there was reasonable evidence to support the charges. Otherwise, there never would have been a trial.
Her office also conducted an investigation. So it's not like there was no investigation and, we're just going to go ahead and charge you.
Look, she's not making any of this up. And this is petty, and these people killed someone, or they were responsible for...
A guy died.
Yeah, someone died in their care that they didn't take care of. And personally, look, I don't know if they're trying to taint the jury. I don't know if they're trying to manipulate the local press, but it's very, very obvious that this is just throwing crap at the wall in the hopes that they can somehow intimidate her or intimidate potential jurors for their cases down the road. Because there's no reason to believe that she did not have all of her ducks in order before she brought these people to trial.
Well, again, the reason I brought the Chicago case up, because what you're seeing here is you're seeing these cops, and that's why I'm going to deal with Bill O'Reilly, his lying behind later. These cops are mad that somebody is standing up to them and trying to hold them accountable.
Exactly, exactly. And that's been the problem across the board for the last few years as we've been watching this with a microscope, that police officers believe you cannot talk back to them, you cannot challenge them, that they're the ultimate authority in our society. They arrest you, they're the jury, they're the executioner. And if something goes wrong, that's our job.
And I'm concerned about her immunity. I'm concerned about Marilyn Mosby's immunity because I want to know where do they get the gumption to be able to go and sue the prosecutor? That just makes no sense to me at all.
Yeah, and the only reason they can is if she's actually lying and knew it was a lie and would assume that she didn't do the investigation. All these things are false. She did an investigation, and she did a more thorough one than many prosecutors do before they decide to make felony charges. And you're absolutely right, Joy. The idea that the immunity that's in question, according to the officers, is theirs. And they are not immune to the law. They're not immune to civil lawsuits. They feel entitled to be able to bring these suits because somebody is acting as big brother towards them. But in reality, they should be questioned. And in this case, in particular, the questioning is right.
And I'm amused by the fact that it's so much easier for a cop to sue the prosecuting attorney than it is for regular people to actually sue the police officer. That's what I'm amazed by in this situation.
The officer who has not gone to trial, you would think she would want to keep her head down.
Yeah, she tried in this particular case, she tried to get the documents sealed so that she wouldn't have to have any of her statements be before the public, because she obviously realizes she is facing one of the more serious charges as the supervisor, as the person who was present to say what you should have done with Freddie Gray in the back of the van. So she tried. The judge said, no go.
This is simply another example of cops wanting it both ways. And then they don't want any accountability. They don't want to be checked. They don't want to be videotaped. They don't want to be questioned. That's all this is, and it's shameful. Final comment real quick.
And even in the face of all that, I have questions about her investigation. You know, that's been called into question, but I'm wondering, really, what kind of case do they have even after she conducted her
But here's the deal. Here's the deal. I don't have any questions about her investigation, because you know why? You charge somebody, you go to trial, you're either innocent or guilty. That's the whole point of the trial, to be able to go through all the facts.
And that's really
so the case with the Nero case, it was a trial by judge. The judge heard all evidence, made his decision. And I think what a lot of people in the public are saying, even if you're upset that the officer was found not guilty, at least you, first of all, had an indictment. At least you actually had a trial. At least you had a public display of the facts. The problem is when these cops don't even want a trial, don't even want an indictment, don't even want a grand jury inquiry, don't even want an internal inquiry by the police department. It's just accept my word, and that's it.
And the prosecutors don't do anything to even bring these to an indictment.
Absolutely. Folks, coming up, we'll talk